Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Today, Ross will discuss why digital assets should be incorporated in the estate and business planning process, and what are some of the initial steps to take when formulating a plan. Ross, in our last episode, we discussed generally what digital assets are. For listeners who may have missed that episode, can you provide a brief description?
Under the Uniform Law Commission's Revised Uniform Fiduciaries Access to Digital Assets Act, or we commonly would call RUFADA, the definition provided there is digital assets are defined as an electronic record in which an individual has a right or an interest. And electronic, under that RUFADA, means anything relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities. So obviously that's a very wide definition of what applies to digital assets, and that can mean anything from music files, or MP3s that are on your phone or on your computer, digital photography, electronic communications like emails, or even cryptocurrency, like we talked about in the last episode, that has significant financial value.
Now that we have an understanding of digital assets, why is it important to incorporate them in an estate or business plan?
So the goal of any estate plan is to help an individual move his or her assets to a designated beneficiary. In the case of estate planning with digital assets, it's more complex because there's a lack of understanding about the rules involved and how to gain access to those digital assets and how to transfer them and what impediments are along the way. So it's the same fundamental concept of any estate planning, but heightened in terms of complexity due to the nature of the asset trying to be transferred and whether or not his personal representative is going to succeed in making that transfer or even finding the asset to begin with.
How can an individual begin to create a plan for their digital assets?
Great question. I think that the most important thing to talk about with clients, or it's for individuals to think about, is to identify all of their individual assets. When people sit down and think about all the online accounts and all the different files that they have on their computer, on their phone, or any other device, they'll begin to realize this is a much more complex and much more vast world than they thought about before engaging in digital asset planning. So not only for their own benefit of understanding their entire universe of digital files and digital assets that needs to be transferred, it's also going to be helpful for their personal representative to know what's out there, where to look for some of these assets. So the first thing is identifying the assets and creating some sort of inventory. The next thing to do is to think about who should have access to these assets. Some things are simple to think about. Take your typical online photo album. That can be copied and duplicated and shared with as many beneficiaries as the testator desires. And that's something to consider in terms of who should have access to those online files. Other digital assets, like we mentioned cryptocurrency a little while ago, that cannot be duplicated. It is a single asset and can only be designated to one beneficiary, and that needs to be kept in mind of who should be the recipient or the beneficiary of those select assets.
Can you tell us about any federal laws that are currently in place that impact digital asset planning?
Yes, I can. And there's two primary federal laws that must be kept in mind when we're dealing with estate planning with digital assets. The first one is the Stored Communications Act. And that's 18 U.S.C. Section 2701. That puts a restriction on custodian or providers to share electronic communication outside of those who are entitled to that information or who have lawful consent to receive that information. Your custodians and providers, think of them as your Facebooks, your Googles, your Yahoos. They are the individuals or the entities who are storing these digital assets and have control over them. And the Stored Communications Act says that a user or an entity providing electronic communication services can't knowingly divulge the contents of a communication electronically stored by the service provider or by the custodian. So there's an exception to the Stored Communications Act where custodians or providers can share information, and that's if they receive lawful consent from the user. Unfortunately, the Stored Communications Act is silent as to whether or not this applies to fiduciaries. So we're in a bit of a gray area as to whether or not a testator can provide lawful consent to his or her personal representative and thus provide some sort of safe harbor to the custodian. Thus, you have a world where custodians are very reluctant to provide any information that might violate 18 U.S.C. 2701 when sharing with an estate or a trust. The other law that we want to talk about is the Computer Fraud and Abuse Act, which is 18 U.S.C. 1030. And this was created in an effort to combat hacking of electronic devices and unauthorized access to digital information. It provides criminal sanctions against anybody who fraudulently or intentionally accesses a computer without authorization. And this, too, is silent as to whether or not it applies to fiduciaries. So again, creating another gray area where fiduciaries and their legal advisors need to be concerned about whether or not sharing or transferring digital assets in an estate administration or as part of an estate plan violates either of these two acts.
Ross, are there similar state laws for the Computer Fraud and Abuse Act that would apply on a state level?
There are. All 50 states have some version of that act on their books. And so not only do we have to worry about this from a federal level, but every single state and every single transfer within a state needs to be mindful of the state version of this.
A few years ago, the Uniform Law Commission drafted and then revised an act now commonly known as RUFADA, which you told us about a little earlier. And RUFADA addresses a fiduciary's ability to access digital assets. Many states have passed a version of this legislation. Can you tell us a little bit more about RUFADA and how it intersects with the federal laws you just described?
In order to provide that safe harbor that I mentioned before, for custodians to feel safe in transferring electronic communications to a fiduciary, or to help custodians or fiduciaries be certain that they are avoiding committing a violation of the Computer Fraud and Abuse Act, RUFADA has created a path forward that allows fiduciaries to follow a certain protocol in their attempt to obtain and transfer digital assets and electronic communications. It does so through a hierarchy. And the hierarchy is that first, custodians and fiduciaries must look if there is an online tool that the user, the decedent, utilized during his or her lifetime that provided that lawful consent that we were looking for under the Stored Communications Act for the fiduciary or another individual to access the information, to access the electronic communications and the digital assets. Online tools, although valuable in terms of the RUFADA hierarchy and obviously the top of what should be examined and where we should look to determine who has access, are underutilized at this point. Google has an online tool that users can fill out and designate who the individuals that can access their account should be, should they pass, or should that account become dormant. Facebook also has a similar online tool where it gives it creates a legacy account and allows users or loved ones of the users that the user designates to access that account and make some, but not all, changes. Aside from those two major players, not many custodians at this point have set up online tools. And so more frequently we need to look to the next level of the hierarchy under RUFADA, and that is if that lawful consent is provided for in the decedent's estate planning documents.
So Ross, what happens if the person designated in the online tool is different from the administrator or executor of the user's estate?
Problem created by that conflict is that you will have different individuals who have different roles in the estate administration process, some in a formal capacity as the executor, as the administrator, and some in an informal process in terms of probate and estate administration who have been granted access under that online tool. and they will have different levels of access to the electronic communications and digital assets. Because of the hierarchy of RUFADA, the online tool trumps any other estate planning documents if it is utilized. And therefore, you could have a situation where you've given someone access who has no other connection to your estate administration process, access to electronic communications and access to information that no one else in the entire probate process has and may be necessary for them to move forward with helping the administration process. Therefore, it's imperative that users understand who they're granting this access to and have a conversation with their executor and with their attorney about who's playing what role and making sure everyone's on the same page. And individuals who need information are not cut off by this selection of a designated recipient of the online tool.
So these online tools could really mess up a well-crafted estate plan if the attorney isn't consulted, or maybe if the user isn't aware of the interplay between the online tool and the estate planning documents.
It can, and going beyond just who is named as the user's designated recipient of that information, that designated recipient can also, and under some online tools, possibly be given access to the actual not just the information that is there, but actually given the digital asset. So it's equivalent to a transfer on death account at a bank that it does not fall under the decedent's will and under the guidelines of what they spell out in their estate planning documents, but rather is transferred immediately upon death, as you said, disrupting the entire estate plan that was intended.
So what other types of documents should address digital assets?
As I mentioned, wills should have digital asset clauses in order to address the issue just named in both the Stored Communications Act and the Computer Fraud and Abuse Act. Complying with RUFADA through your will is the primary way to make sure that your executor will have the power to gain access to online accounts that they'll need in order to properly administer your estate. Beyond wills, trusts can also include digital asset clauses, as can powers of attorney during the principal's lifetime. Their fiduciary, their agent acting under the power of attorney, may need to access some of these online accounts, and therefore it should be spelled out in that power of attorney document as well. And last but not least, even guardianships, because the incapacitated person may also have some version of online accounts or digital assets that need to be handled and administered, and without that granted in the guardianship or any of the other estate planning documents we just mentioned, you're subject to the third tier of the hierarchy that we talked about under RUFADA, and that is the terms of service agreements provided for by the custodians.
So when you're writing your orders for a guardianship, you want to make sure that there's lawful consent in that order so that the guardian can act on behalf of the incapacitated person's digital assets.
I think so. I think you're trying to specifically address the concerns raised under the Stored Communications Act, and providing that lawful consent within that clause is one way to address that. 10 years from now, I think we'll be in a very different world in terms of estate planning with digital assets and estate administration. As more decedents pass owning digital assets, we'll have clearer pictures of exactly how these are treated in the administration process, and we'll refine what digital clauses should look like. But for now, I think you want to make sure that, at the very minimum, covering that lawful consent under the Stored Communications Act.
Ross, you mentioned earlier about terms of service agreements. Can you tell us a little bit more about how that can impact estate planning for digital assets?
We talked about the hierarchy of RUFADA. At the top was online tools. If an online tool doesn't exist for an online account or with a custodian holding digital assets, we look next to the estate planning documents of the decedent. If the digital assets or electronic communications are not addressed through those estate planning documents, we finally look to the terms of service of the custodian. Under the terms of service that the user agreed to when they started to use the custodian's either software or online platform or gain access to that account, they agreed to something. And every custodian has a different terms of service agreement, that provides different rights and different access to account information, to electronic communications. So it'll be spelled out in there. But relying on terms of service agreements can be tricky because not every custodian is going to allow access to these assets. In fact, based on both the Computer Fraud and Abuse Act and the Stored Communications Act and their concerns of violating each of those, they're typically fairly restrictive in who can gain access to any of the information contained in the user account. So that's why preparing planning documents that include digital asset clauses or utilizing an online tool when it's available is so important.
Thank you for listening today. We hope you enjoyed our discussion and that you'll tune in next time when we explore the topic of administering an estate with digital assets.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.